replaying clips from the Quentin Tellis case from 2017 out of Mississippi, where he was charged with the brutal murder of burning 19-year-old Jessica Chambers alive. Really, really disturbing and brutal case, which we covered. And the reason we are covering it again is because we anticipate in this upcoming year, in this upcoming term, that Mr. Tellis will be retried. Remember, his trial ended in a hung jury. The jury was split. Those thought he was guilty, 7 thought he was guilty, and the others thought that he was not guilty. And now we're trying to determine why did that happen. So we're replaying all clips from that whole trial to understand it, and we're going to analyze it in a little bit later today. But right now, I want to focus on our last special segment of the morning with our very special guest, criminal defense attorney Mark Eiglarsh. Now, Mark, this is the last case we're covering. Unfortunately, I wish we could have you all day. You've been terrific. But here's the last case that we have. The Connecticut Supreme Court is expected to rule this year on whether to reconsider its 4-3 vote reinstating Michael Skakel's conviction in the 1975 murder of 15-year-old Martha Moxley. A lot of people who've been following our network will know this case. Michael Skakel, remember, he is the nephew of both Robert and Ethel Kennedy, and he was originally convicted in 2002. However, in October 2013, a Connecticut appellate court ordered a new trial for Mr. Skakel. They found that his defense attorney, Mickey Sherman, his representation was constitutionally deficient. So Mr. Skakel was released on bail. It was only 3 years later that the Connecticut Supreme Court reinstated his conviction in a 4-3 decision, pretty close, 4-3 decision. And now what has just happened in January, we just saw this, Skakel's attorneys have filed a motion to reconsider the ruling of the Connecticut Supreme Court. Now, Mark, my question to you is, a motion to reconsider this decision about whether to reinstate his conviction, in general, motions to reconsider, are they usually granted? What's the process that Mr. Skakel will go through here?
The answer is no. Those who are betting on this should bet on the side of the courts upholding their prior ruling. Motion for reconsider, kind of like, you know, my son says, but Daddy, can't I stay up a little later? You know, maybe. All right, he has a better chance with me. Appellate courts generally are not in the business of reversing themselves. So while it does happen, statistically, that number is very low.
What are some points that would help him? Does there has to be a change of some kind, something that was discovered that wasn't discovered before? What would be in his best interest to happen for him?
I get calls all the time where family members want to throw money at a problem saying, you know, I got somebody serving life, please take the case, do something. Most of the time I turn them down because I say, what's new? What will change, you know, the course of this case? And to answer your question, what motivates me would be something new, a new witness, something that was never revealed to the higher courts and needs to then go in a brief to the appellate court. But other than that, to say, well, just look at it again, I'm calling a legal do-over. Our system would shut down if, you know, time goes by and we can have new justices just, you know, try to consider whether their, you know, nemesis made the right decision a couple of years earlier. The system shouldn't work that way.
Mark, you talk about something new. What makes this case a little unprecedented is a specific issue here, and it's the timing of it is very weird. The judge who authored this majority decision, again, it was 4-3, pretty close, he retired from the court. And the question becomes what to do. This is Justice Peter Zarella. He left the court. So in the Michael Skakel's motion, he said he is requesting the court, if the court is unable to reach a majority decision on this motion about whether to reinstate his conviction, a replacement justice should be summoned to break the deadlock. Because again, there could be a 3-3 split. The state, however, is saying that's nonsense. They're saying there is no legal authority for their claim that a defendant is somehow entitled to have a 7-member panel for this motion for reconsideration. Which way do you side on this?
Oh gosh, I'm no expert in this state's appellate, rules and procedures, but I don't understand what they're arguing here. The decision has been made. They're moving for reconsideration. I don't think that they get somebody else. I think that the decision has been made, and And I don't like their chances here. But again, for them to accept defeat means this man goes back to prison to serve out the remainder of his 20-year sentence. So they're going to keep arguing. They're going to make motions. I just don't like their chances.
It sounds a little bit like when a president wants to appoint a Supreme Court justice to push a certain agenda. What I imagine what he's trying to do here is say, look, if I could get a different justice on there who might be more sympathetic to my case, maybe I'll get it on there. What I find is really interesting is the state is saying, Mr. Zarella, Justice Zarella, yeah, he left the court, but that doesn't necessarily make him disqualified. He's in private practice. Doesn't mean he can't come back to the court to make this decision, which, by the way, I don't even think Mr. Skakel would want, because this guy authored the majority decision. And 4-3, that's pretty close, right?
Let's talk about that for a second. I mean, it really is very, very close, the closest you can get. I mean, if one person makes a different decision, one person, he doesn't have to do 20 years in prison. His conviction's overturned. It's bizarre that it comes down to that. You know, human beings are inherently flawed. They have certain mindsets, and, you know, it's just that close. It's just so frustrating, I'm sure, to many of the Kennedy relatives who strongly believe that this is a miscarriage of justice.
Let's talk about that, miscarriage of justice. The main underlying issue was Mr. Skakel properly represented? Well, again, in 2013, when that Connecticut appellate judge ordered a new trial, he said, the defense of a serious felony prosecution requires attention to detail, an energetic investigation, and a coherent plan of defense capably executed. The trial counsel's failures, meaning Mickey Sherman, in each of these areas of representation were significant and ultimately fatal to a constantly adequate defense. We hear all the time about a threat that my attorney wasn't properly representing me. Here, there seems to be some meat to this argument.
Maybe, but let me, in the interest of disclosure. So I'm out in Colorado. I'm on a ski lift, and I turn to the guy next to me. You know, you usually chat, and I asked him what his name was, and I learned it was Mickey Sherman. And he was the featured speaker at a seminar that I was going to for criminal defense attorneys. And I hit it off with him. And what made him so compelling were the words that flowed from his lips and the way that he spoke when he gave this seminar. I was riveted. That guy is was a very talented attorney. When I heard the ruling in this case, I went, really? I was shocked to think that an appellate court didn't just say whatever he did or didn't do was for the benefit of his client. You know, we all make judgment calls. There are certain witnesses that I won't call to testify strategically, or there's certain ways that I will cross-examine someone, all for the benefit of my client. I find it hard to believe that Mickey Sherman ever made choices that put himself first versus his client. And thus, when the conviction was reinstated, the justices then wrote, yeah, we believe that his representation didn't violate the Constitution. You know, listen, you could fall asleep in Texas during a murder trial, and they say, well, he didn't fall asleep during the critical parts of the trial. I mean, it doesn't take much for an attorney to provide sufficient, adequate representation. And so, you know, I think they finally got it right.
Let's just break down what the grounds would be, and if that's even justified for an inadequate counsel claim. We're saying that the claims are that he failed to fully investigate and implicate the Mr. Skakel's brother in the murder. We don't even have to get into the details. I'm just general perspective, that he failed to investigate someone that might have been implicated, that he failed to investigate and present an additional alibi witness who Mr. Skakel claims saw him at a house on the night of the murder, and then that Mr. Sherman failed to call 3 additional witnesses who would impeach the credibility of another witness that claimed that Skakel told him that he committed the murder. So again, these kinds of things that you didn't fully investigate, you didn't call witnesses to impeach the credibility of another important witness, or you failed to investigate an alibi. Is that enough to say, hey, I had an ineffective assistance of counsel?
It could be. I mean, every case is different, right? Originally it was. Some justice or justices believed that it was, right? And if he was allegedly watching Monty Python on television at a friend's house like he claimed, and there's a witness there and the defense lawyer just chooses not to call him, and, you know, and on and on and on, it could mean that the attorney was ineffective. I don't think that was the case here. He's too good. Mickey Sherman is too good. I believe if he didn't call them, it could be for the same reason why I don't call certain witnesses. You meet with them and they just aren't credible. They're going to be a horrible witness. You know, you think you can win on reasonable doubt for other reasons. You make calls all day long. Rookie lawyers call everyone. Rookie lawyers throw everything in. No, you've got to know how to make your defense a lean filet mignon without the fat on there. And that means you don't call certain witnesses and you don't pursue certain things that your client tells you to do. And if the outcome is that the appellate court at one point says that you're incompetent, so be it.
And I think our viewers on the Law&Crime Network would really appreciate that comment, because we see so many witnesses who are called to the stand by the prosecution and defense, and afterwards you're like, I don't know which side that helped. It seemed like it helped the other side. So you make a great point that that ultimately might be what it is, and we didn't know the strategy back in 2002 when this trial was going on. So you know, it's an interesting thing to look at, because of obviously a lot of people follow this case. They know who Michael Skakel is. They know who the Kennedys are. They know about Martha Moxley. But in your opinion, you think this guy's going to be spending the rest of his life, or not even the rest of his life? I think he was not even convicted of sentenced to life. But do you think he's going back to jail?
Yes. I think that if you're simply playing the odds, I think that the appellate court generally doesn't reverse itself. I mean, anything can happen, but you're just playing the odds. I think there's a good chance. I also don't like this notion that I think they got lucky, quite frankly. I think that you're not entitled. The Constitution doesn't guarantee you great representation. It's effective assistance of counsel. That's a very low threshold. You walk around any courthouse in this country and look, and you would think like these lawyers are horrible. Well, they still are way above the competency level that's required under the Constitution. It's a very low bar. So to say that Mickey Sherman somehow was incompetent, you know, it doesn't surprise me that they reversed themselves. And the best argument that they had, which was try to claim that the attorney was incompetent, worked for a period of time. It got him his freedom. He posted the $1.2 million bond. He got a I don't know, a long furlough. And I think ultimately the conviction will be, you know, will stand.
Yeah, well, we can't wait to watch what happens this year. Again, we've been covering all what is going to happen in 2018. Mark Eiglarsh, thank you so much for joining us today. You've been amazing. We love talking to you about these cases this morning. We can't wait to have you back on. Maybe when we're covering a real live trial, we can get your real-time update.